Hi, today we will discuss on immoral works, religious works, seditious works, and obscene works under Copyright Act 1987. My name is NURSYAZRIENA binti Yaakob, and my metric number is 264562, and I will briefly explain on the topic that we will discuss today. So, Malaysia implemented the Copyright Act to protect the works. Copyright law is a branch of intellectual property that protects the proprietary rights of the authors. This act allows the authors to expose and expand their creativity as the works are being valued and protected. This will entitle whoever infringes it to be charged accordingly. So basically, Copyright Act protects various forms of works such as literary works, artistic works, musical works, and sounds recording. The basic concept that Copyright Act protects is the expression and not the idea or concept. Work and automatic protection towards the works that fulfill the requirement of statutory provision. Meanwhile, the elements of the copyright is the originality of the work, physician, and the qualification for copyright itself. Malaysia participated in several treaties that concern about the intellectual property or in specific the copyright itself. For instances, Malaysia joined the Berne Convention, Agreement on Trade-Related Aspects of Intellectual Property Rights, TRIPS Agreement 1994, and WIPO Copyright Treaty, WCT 1996. These treaties covered various guidelines about the application of the copyright protection. However, the issue arises on the extent of protection of the work, as the treaty silent on the types of work that shall not be protected, including the Copyright Act 1987 that implemented in Malaysia. The type of work that shall not be protected did not clarify. It is undeniable that the law did mention the types of works that shall be protected. The question on the works that contradict with the public interest or public policy that is worrisome to the citizens shall be protected or not. The contradiction can be seen on the works that related with immoral works, irreligious works, seditious work, and obscene work. Malaysia's law silent in this type of works. However, according to the Section 3 and 5 of Civil Law Act, we may apply English law in Malaysia if there is lacuna in the local statutory provision. English law did protect the type of works, as they believe if it is follows the element of the copyrights, their right shall not be denied. Meanwhile, the application of English law shall not be implemented if there is precedent on the same issue in Malaysia.
Hi, my name is SAHDUN 264678. So now I'm going to present about the immoral work, whether it has the right to be copyrighted under the copyright law of every country or not. So basically, under the Copyright Act 1987, all new works or new invention created by any individual will be automatically granted with the right of protection under this act. Any attempt made by any individual to copy such creation is deemed to be an act that have been infringed the exclusive right of the creator again to protection against his works, and will be held guilty, and punishment will be served to the wrongdoer. However, such work will only be granted with such protections if the idea or the concept of the work is transferred into the physical form subject to certain conditions. So the issue here is that immoral work is massively produced around the world, and it demands the protections under the copyright law by the producer of the country. Therefore, the copyright law around the world has experienced some changes with the purpose to suit the current situation. So now let's look at the situation in the country that is called as United States of America. In the case of Submitted against Gordon, the court held that the book, which is started at Hell's Playground, had no copyright protection because it has the elements of insulting the God, and insulting the God, and the act of insulting the God is deemed to be immoral, and therefore making the whole work as immoral work. And that is the reason why the court held that there is no such thing as writer protections that will be granted to the immoral work under this case. The whole purpose of having copyright law in the country, for your information, is to encourage the productions of the literature work that hold the best and that could elevate the beneficial impact to the society as a whole. So, moving on to the next slide, which is that several years later, a court of law considered the problem for the first time and adopted the approach of equity. And the law where states that the illegal or immoral work that are recognized to be not eligible to be protected by copyright later has changed, and the elements of equity that has been approached, it makes the United Nations adopted such approach in the law as a part of the English common law tradition. And nowadays, productions of immoral work has become a successful industry that contributes to the increment in the financial status of the country. Hence, such work is not being recognized to be eligible for protection under the copyright law, but usually such cases will only be treated as where the court will only grant injunction for the solution to it, and no reward will be given to the plaintiffs of the case. Now moving on to the law that we have in this country, which is called as Copyright Act 1987. For your information, everyone, there is no specific provisions that states that any work which is deemed to be against the public shall be protected. Thus, in tackling this issue, an effective approach has been conducted where, based on the Section 3 and 5 of the Civil Law Act 1956, it allows the adoption of any law in the United Kingdom to be applicable in this country when there is loophole found in any law in Malaysia. So, here I provided a case from United Kingdom, which is called Aglean against Western Feature Film Co. It was held that clear law that copyright cannot exist in a world of a tendency so grossly immoral as this, a world which, apart from its other objectionable features, advocates free love and justifies adultery where the marriage tie has become merely a sum. However, to describe any word to be grossly immoral is difficult, as there is no exact indicator to measure how grossly immoral of a work is. So, under the Malaysian Act, after consider all the approach from the United States situations and also the United Kingdom cases, so under the Malaysian law, any creator who is the owner of any immoral work wish to get protections under the Copyright Act 1987 shall not be allowed. It is because those individuals who owns any of the immoral work is said to have committed an offense in this country. And furthermore, our government has been putting so much effort in ensuring that any form of work that is eligible under the Copyright Act 1987 upholds the intentions of the legislator to maintain and give an exclusive right to the creator of the work while preserving and nurturing a good moral in any person among the society through the productions of new creation. Immoral work is said to be against the government policy, and therefore it is not eligible for any protection under the Copyright Act 1987.
Assalamualaikum and a very good day. My name is AIMAN bin ROSLI, number metric 264746. And for today, I'm going to present on irreligious works under copyright. Irreligious can be defined as not having interest to any religion or protesting any religion. This means that irreligious work in the context of copyright is when the work involved elements that shows lack of interest or hate towards any religion. The general rule involved under copyright is it ignores the merits of quality in the works. However, if the work involved with the elements that show no interest or hate towards any religion, then it is not entitled to copyright protection. By referring to Article 8 of the Copyright Commission 1878, it stated clearly that any publications involved with any irreligious elements, then such work shall not be protected by the copyright law. One of the cases that can be referred to is in the case of Simonton against Gordon. In this case, the court held that the plaintiff shall not be entitled to copyright for his novel, as the rule is that any blasphemous, seditious, immoral, or libellous works cannot be protected under the copyright law. Now we shall move on to issues and cases on irreligious works under copyright. One of the recent issues that is related to irreligious work under copyright is regarding a cartoon sketch of the Prophet Muhammad, peace be upon him, that was published on the 14th of January 2015 in the Charlie Hebdo's issue number 1178. This was a cartoon sketch of the Prophet Muhammad, peace be upon him, with a tear in his eyes while holding a sign that says, "I am Charlie" in French, and with a caption in French that says, "All is forgiven." This artwork was republished to over 7.95 millions of copies throughout the world, had clearly caused controversial, as it had insulted the Prophet Muhammad, peace be upon him, and the religion of Islam. With regards to this issue of Charlie Hebdo's drawings, we believe that the drawing of such cartoon should not be protected under the copyright law, as it has insulted Islam by drawing a cartoon version of the Prophet Muhammad, peace be upon him. This is because, based on the religious rulings by the Islamic scholars, it was agreed that Islam forbids the drawing of the Prophet Muhammad, peace be upon him, as the scholars fear that such drawing of the Prophet Muhammad may be used for worship. It was argued by the company itself that it is their right under the freedom of speech to express and publish such drawings to the public. However, the freedom of speech and expression shall not protect for any act that goes beyond the limits of law, by which such act has actually violated Article 9 Clause 1 of the European Convention on Human Rights, by which it violated the freedom of religion. Now we shall move on to another issue, which is based on the case of Garcia against Google Incorporation, whereby in this case, an actress named Cindy Lee Garcia, who was an actress in the movie of Innocence of Muslims, has sued the producer of the movie and Google to take down such anti-Islamic films for copyright infringement. This Innocence of Muslim movie is an anti-Islamic short film that was written and produced by Nakola Basili Nakola, by which such film was uploaded on YouTube in July 2012. In this case, Garcia was casted by the producer of the film and was paid $500 to only speak 2 sentences, which was, "Is George crazy? Our daughter is but a child." However, the film producer in this case dubbed over Garcia's line and changed it to, "Is your Muhammad a child molester?" The 2 sentences line in the movie has caused Garcia to receive a lot of death threats, and she decided to sue Google and the producer of the film for violating her right of privacy and her right to control herself, as well as for the hate of speech of the movie itself towards the religion of Islam. In this case, the federal court has dissolved the case by an order to force Google to remove the Innocence of Muslim movie from YouTube, and that there is copyright infringement on the part of the defendant. By referring to this case, it is safe to say that a person, specifically an actor, is entitled to copyright protection under the law for any of the scene that such actor has played, although it was only 5-second scene, and that there is a copyright infringement the moment when a director of a movie used that scene and changed it to his own scene without prior permission from the actor itself. Other than that, with such decision that ordering the producer of such film and Google to take down such movie, it is clear that the producer does not have a copyright protection for his own film, as such movie was only made to show hate and insult towards the religion of Islam, which thereby violating the freedom of speech under the US Constitution.
Hi, my name is ERINA binti ANNUAR. My matrix number is 264773, and I'll be explaining about obscene works, whether obscene works can be copyrighted in Malaysia. So first, we have to understand the definition of obscene works. In narrow sense, obscene works refers to the works or material in relation with pornography, nudity, and sex. So in the case of R. and Hicklin, a work is obscene if the material has a tendency to corrupt those minds who are open to such immoral influences. So the legislation that governs the obscenity in Malaysia is firstly Communication and Multimedia Act 1998, where Section 211 of Communication and Multimedia Act includes indecent act and also obscene content. Next is Penal Code, where Section 292 of the Penal Code provides that it is an offence to sell, let for hire, distribute, publicly exhibit, or in any manner put into circulation any obscene book, pamphlet, paper, drawing, painting, representation, or figure, or any other obscene object. And lastly is Film Censorship Act 2002, where Section 5 of the Film Censorship Act 2002 provides that it is an offence to have possession, control, and ownership or to circulate, distribute, produce, sell or hire of obscene material or film. Thus, we can see that the norm in Malaysia consider that obscene work is something that is against the public policy and also something that is immoral. However, the recent development in the intellectual property indicates for the protection of copyright to all works, including those works which are against the public policy. So this shows that what is seen to be obscene at the present may not be obscene in the future due to social change. So the copyright rules in foreign countries, the general rule can be seen in the American case of Glenn and Western Feature Film Corporation, where the court held that distributing obscene works is a crime. However, in the case of Mitchell Bros Film Group and Cinema Adult Theatre, the issue is whether the Copyright Act allows obscene material to be copyrighted. The court held that the copyright statute does not contain any restriction to copyrighting obscene material. So, as long as the work is original, it can be copyrighted. Mitchell case is the first case that allows obscene materials to be copyrighted. Hence, it bring a significant changes in the court's decision in other future cases. For instance, it is illustrated in the case of Jartek Incorporation and Clancy, and another case of UK case Mediasi 80 Limited and Adams and others. The position of copyright law and obscene works in Malaysia is still unclear. In Malaysia, if a work fulfills the condition under the Copyright Act 1987, the work will automatically be copyrighted. However, according to Rohazarwati, obscene works cannot be copyrighted in Malaysia due to government policy and due to immorality. This is justified by Section 292, 293 and 294 of Penal Code and Section 5 of Film Censorship Act 2002. So, it is suggested that there should be a specific law amended to include clauses in relation with the status of copyright for obscene materials in Malaysia. So, in conclusion, the position of Copyright Act is silent regarding the obscene works in Malaysia. Although other countries have started to recognize the copyright protection for obscene works, Malaysia has yet to decide whether obscene works are protected under copyright or not. Therefore, specific laws regarding copyright of obscene materials in Malaysia must be enacted to make this issue clear.
My name is FARHANA binti Muhammad RADZUAN. My matrix number is 264742 and I will be explaining regarding the seditious work. Initially, sedition as an offense came into existence during the British colonial era. During that period, the communists used to spread propaganda in Malaya to dissent the Britishers' rule. So, in 1948, the British came up with Sedition Act as a tool to overcome the anti-colonial activists and restrict any activities opposing the British government. However, after 1969, there was a riot that happened and the Sedition Act was amended through Emergency Ordinance 1971 and is presently used as a mechanism to suppress freedom of expression. Sedition is not specifically defined under Sedition Act 1948. However, referring to Section 3 and Section 4 of the Act, a publication shall be deemed to have seditious tendency if the publication have any of these effects in its context, including that the publication incite hatreds towards the ruler or the government, the publication incite hatreds towards administration of justice in Malaysia, the publication incite discontent against YDPA or between members of the citizens, promote ill-willness and hostility between different races in the country, or if the publication questions the rights, status, position, privilege or sovereignty protected under the Federal Constitution. An example of sedition offense in the form of publication can be seen in the case of Public Prosecutor against Azmi bin Sharom. In this case, the defendant was a law professor working at the University of Malaya. In 2014, the defendant had written an article and he had posted it on the website called Malay Mail Online. So the article was actually criticizing the political crisis in Selangor that was happening during that time, and some of the remarks in his article was claimed to be seditious, and he was then charged under Section 41B and Section 413 of the Sedition Act 1948, respectively, of these specific statements. In this case, the defendant challenged the constitutionality of the act in question, the validity of the law as it was not enacted by the Parliament. Furthermore, the defendant also argued regarding the Article 10 of the Federal Constitution that highlights the freedom of expression. The court held that the limitation to the freedom of expression is vital if the court deems it necessary in order to safeguard their national security. Historically, as according to the broad principles of public policy, copyright law will not protect a work which is seditious. In Digest of the Law of Copyright, Sir James Stephen opined that no copyright can exist in materials that are seditious. In copyright law and the public interest in the 19th century, Lord Eldon opined that copyright would not protect seditious works. In addition, under the official copyright registration policy, the Copyright Office could refuse registration of the material if the examiner finds that the material is illegal in the sense that it has the tendency to disturb the public policy. From these resources, it can be deduced that previously seditious work is not protected under copyright law. Similarly, Copyright Act 1987 does not exclude works which contain seditious elements from copyright protection. However, sedition works that is protected by the Copyright Act may affect the remedies available for the protection. This is because Copyright Act protect works irrespective of their quality and the reason or the purpose that the work is created. This can be seen in the case of Southey against Sherwood, where in this case Lord Eldon refused an injunction to restrain the publication of Wat Tyler and held that although the work had injurious tendency, the author is still entitled to the copyright protection as long as the work was innocent in its character. So my personal opinion regarding copyright protection for seditious works that a work that is intellectual and original deserves to be protected. For me, even if a work contains the element that criticizes the government or the judgment, provided that the written publication is made with thorough research and to obtain justice, it should be still entitled to copyright. This is to keep the government aware of their action and to keep the citizen aware of what is happening in the country. Intellectual discussion is vital for the progression of the country. However, if the work was created solely on the purpose of inciting hatred towards the respective government body or the Malaysian provision, I believe that the work should not be protected under copyright protection. Thank you.
To conclude, every work shall be protected by the Copyright Act 1987 as long as the requirements of the work to be protected being fulfilled. However, they are the extent of protection given by the Copyright Act. If the work contradict with the moral value, the protection towards that work shall be analysed. In conclusion, even though Copyright Act 1987 cited on the types of work that shall not be protected, the other statutory provision that has been gazetted cover the lacuna in the Act. Therefore, it can be said that immoral works, irreligious works, seditious works, and obscene works shall not be protected.